Hello, I'm Damon Moore. I'm a partner for Moore Odeterin, and this is the first in our three-part video series on alternative dispute resolution. As an alternative to litigation, alternative dispute resolution, or ADR, includes mediation, arbitration, and collaborative law, among other things. In part one of this series, I'm going to talk about mediation. In part two, I'll talk about arbitration, and in part three, I'll talk about collaborative law. So let's begin. Mediation is a process in which a neutral third party, typically called a mediator, assists the parties in reaching a resolution for their case. The mediator will meet with the parties to the dispute and the counsel for those parties, or if the parties elect not to use attorneys, then the mediator will just meet with the parties to the dispute. In traditional mediations, the mediator does not reach a conclusion for the parties, doesn't create the documents. The mediator just facilitates the creation of the documents. There's no court reporter that's used, and there are no rules of evidence except for certain rules related to confidentiality. Everything that's discussed during the mediation remains within the mediation. And so if there are any documents that are created, those documents are destroyed. Confidentiality is meant to be maintained at all times. And part of the reason for that is to allow the parties to be able to work towards a solution without fear that what they say during the mediation is going to be used against them in a trial. There's several advantages to mediation. One, you get a custom order that's created by you and the other person involved in the mediation. If you go to litigation, then the parties or the dispute is ultimately going to be determined by a judge. And so you don't have that customization that you would get if you go through mediation. You can avoid the emotional and the financial cost of a trial by going through mediation. You don't have to discuss the private details of your life in a courtroom. And the settlement happens on your schedule, not on the schedule of the court, or not on a trial date that's determined by a judge or by the opposing party to the case, as often happens during a mediation. For example, in some counties, the judge will not listen to a case on Wednesday, Thursday, or Friday if the case is longer than 3 hours. If the case is longer than 3 hours, they'll only listen to the case on Mondays and on Tuesdays. Well, if you're a person who has a long matter that needs to be resolved, but your off days are on Wednesday, Thursday, or Friday, then you could potentially have to take a day off of work, which would cause you to lose financially in order to bring your case to its conclusion. Well, mediation helps to prevent that scenario from occurring. And then finally, one of the key benefits to mediation is that you're able to bring your case to its resolution without involving the children in the same way that you would if there was a trial. If there was a trial and the child was old enough, there's a very good possibility that a judge or the opposing party might ask that the child be made to testify either in open court or in the judge's chambers. Mediation prevents that uncomfortable situation from occurring. And so those are some of the many reasons that mediation is an excellent alternative to litigation. Stay tuned for part two, where we'll talk about arbitration.